First case on the docket for Monday, December 13th, 2021 is appeal number 120935. Eugene Bicknell and Eugene Crawford County, briefs both sides.
Thank you, Mr. Shima. Counsel, will you please enter your appearances?
On behalf of the Bicknells, Your Honors.
Counsel, you may begin with your argument. I would note, just for everyone's, that we obviously have an empty seat. Justice Deagle has recused from this appeal. For those who are watching today, I might explain that that means he will not participate in today's arguments, but also he will not participate in any aspect of the court's deliberations, decision-making, or the processing of the appeal. With that, Mr. Hudrick, you may begin.
Thank you, and the microphone's a little low, so if
Okay.
I need to.
I think you're probably being picked up okay without
Okay,
making
just let me know if you can't hear me.
Okay.
I would like to reserve 4 minutes for rebuttal, if I could, Your Honor.
All right, you may. Thank you.
And before I begin, I'd just like to commend the court for the work over the last 2 years of handling the pandemic, and not only the court, but the staff as well. And it's an honor to be here to be the first person to present in 2 years, so thank you. This appeal arises from Crawford County, where Eugene Bicknell appealed a decision from the Board of Tax Appeals concerning his residency. The district court found by clear and convincing evidence that Mr. Bicknell had established a Florida domicile related to his tax years of 2005 and 2006. That matter was appealed by the Department of Revenue to the Court of Appeals, which reversed. That's the procedural posture that brings us here. Although our briefing sets out more fully the reasons that the Court of Appeals decision should be reversed, I plan to focus on 3 primary areas for today's argument. First, the majority's decision should be reversed because the district court did not shift the burden of proof. It simply weighed the evidence. Second, the majority's holding that Gene must prove he lived apart from his late wife, Rita, in order to establish a separate domicile is contrary to both the case law of our state and the state's regulation. And third, the majority incorrectly held that venue was improper in Crawford County, and even if venue was improper, any such ruling was harmless error. Unless the court would like for me to address those issues or any other issues, I plan to take those up in the order I presented them. First, the district court did not shift the burden of proof in this case. In fact, the district court expressly noted multiple times that Gene bore the burden of proof. For example, on page 32 of its opinion, Judge Smith stated that, quote, "It is then incumbent upon Gene to demonstrate that he had met the necessary criteria as established by his actions and statements to establish a domicile of his choosing." The decision is replete with examples where Judge Smith talked about the necessary burden to show intent to change domicile and how it was Gene's burden to handle that. And this case is unique in that there's not much dispute as to what Gene did in these actions. The dispute is primarily concerned around why Gene took the actions he did. For example, there's no dispute that Mr. Bicknell voted in Florida from 2003 forward. There's no dispute that he changed his estate documents. There's no dispute that he had a driver's license or that he had a house in Florida. The question is, why did he take those actions? Gene contends that he took those actions to become a Florida resident. The state contended that, quote, "Gene is a classic example of a seasonal resident trying to establish domicile on paper." In fact, the vast majority of the state's arguments, both below and its briefing here, is dedicated to arguing factual issues as to why Gene took the actions he did and asking the court to disregard them. To satisfy his burden of proof, Mr. Bicknell set forth documentary evidence and numerous friends and family who testified as to his intent to support his version of why he took the actions he did. The district court simply noted that the state produced no witnesses who contradicted this testimony. It weighed the evidence that Jean presented. This does not shift the burden of proof, but merely weighs the evidence.
Counsel.
Yes, sir.
Let me ask you, what about the regulatory presumption or the spousal presumption? The Court of Appeals highlights that as an example where it appeared that there was an undisputed fact concerning Rita's residency. Can you address the burden-shifting defense to that particular issue?
Absolutely, Your Honor. Thank you. That's also part of my points as well, but I can address that now. As it relates to the spousal presumption issue, that is a red herring that the Court of Appeals just frankly got wrong. And the reason it's a red herring is that the spousal presumption, KAR 92-12 4A subsection B5, states that a person wishing to change domicile shall be presumed to have the same domicile as their spouse unless 3 criteria are met, one of which is unless there is affirmative evidence to the contrary. It is undisputed there was affirmative evidence to the contrary. There was a plethora of evidence to the contrary. In fact, Judge Smith found that Jean had overcome the presumption by clear and convincing evidence. So therefore, the presumption doesn't matter. If Rita was found to be a Florida resident, if the court decided to disregard the stipulation of law, as Judge Arnoldberger said in her dissent, and she's a Florida resident, the presumption doesn't apply. If she is a Kansas resident, as we stipulated to in pretrial order and throughout this case, then the presumption still doesn't apply because the exception of the spousal presumption expressly says that if there is affirmative evidence to the contrary, the presumption does not apply. Notably, the Court of Appeals did not address that issue in its decision. It simply noted the spousal presumption but did not address how the presumption was overcame by the affirmative evidence to the contrary. Does that answer your question, Your Honor?
Yes, it does. Thank you. And is that conclusion, I'm sorry, Chief. Is that stipulation a question of fact or is it a legal conclusion in terms of Rita's residency?
I think that's an interesting question, Your Honor. I think that the decision as to whether or not she is a Kansas resident is a legal conclusion that is based on factual stipulation or based on factual evidence. And this is where, Judge Smith and the dissent talked a little bit about it as well too, where the state argues that Jean's representations and self-statements and desires cannot be enough to establish his domicile, but then turns around and says that Rita's representations and intent is enough to establish her domicile. But regardless of how we get to that point, it is irrelevant in the sense that even if she was a Kansas resident, even if it is accepted as fact and found as a conclusion of law that she's a Kansas resident, the presumption is still overcome by the affirmative evidence that was entered before the trial court. Yes, Your Honor. So
I take it that from that answer, because I was going to ask basically the same question, that you would not say it's a mixed question, that there are that there need to be factual findings, but then ultimately the legal conclusion. Is that what you're saying?
Yeah, I would say that residency for anyone is a legal determination based on the factual evidence that is presented. It is determining one's subjective intent by objective factors.
But wouldn't a stipulation be binding as to a fact?
Yes, it would be binding as to a fact, yes. And I want to be very, very clear.
Start with Rita's residence is Kansas.
Yes, and I want to be very clear that the Bicknells are not contesting, have never contested, that Rita was not a Kansas resident at this time. We said that in the trial court, that we stipulated that she was a Kansas resident. That's what she testified to. We have not contested that at any point in the lower proceedings.
This may be somewhat of a rabbit hole we don't need to go down, but it's something I don't understand. If you have a Kansas resident and a Florida resident filing a joint tax return, why does the fact that there is just even one Kansas resident not make that joint return taxable in Kansas?
Well, I think, Your Honor, I'm not an expert on the procedures as far as the tax return goes, but I believe there are procedures that allows for this procedure to happen where spouses can claim separate domiciles and file as one return, even though they have separate domiciles. That is something that I believe we addressed at an earlier proceeding, but that's something that is more of a procedure of the tax filing as to how that is equipped by the state as opposed to the domicile issue.
So for our purposes, we only need to look at the impact on the presumption, not on any legal effect of that? on the
Yes, Your
tax.
Honor.
Okay.
The presumption stated in the regulations is very clear that if there is evidence to the contrary, the presumption does not apply, or the presumption is overcome, I should say. And the record is very, very full with evidence that is contrary to the presumption to overcome it. But going back to the weighing of evidence that the court addressed, the court simply weighed the evidences in the Gene had put forward. It did not require the state to present any evidence. It did not require the state to prove that Gene was not a resident. And this case is very different than the Peck decision that it was cited by the Court of Appeals. In Peck, the district court stated that the residence committee could not draw a negative inference from Peck's failure to present evidence on any of the given factors of the regulation. The Court of Appeals in this court held that that was a shifting of the burden of proof. It made the residence committee then prove that Peck was not a Kansas resident, as opposed to keeping the burden on Peck. This case is much more akin to the Blue Cross Blue Shield case cited in the dissent. There, the testimonial team was charged with presenting evidence to carry its burden of proof as to the effect of a merger between Blue Cross Blue Shield and Anthem. And the testimonial team did put affirmative evidence up that said, as to the effect on premiums and other issues that were relevant in the discussion. In her decision, the commissioner noted that there was little to no evidence that was put up by the insurance companies to address those factors. The Kansas Supreme Court said that that was not a burden shifting, that was just a commenting. That was just weighing the evidence and a comment on the evidence that the testimonial team had put forth, not a shifting of the burden of proof. And it's the same thing we see in criminal cases. In the Dough case, D-O-U-G-H, that was cited in our brief. There, the court held that there was no shifting of evidence by a prosecutor's conduct commenting on the defendant's explanation as to the occurrence of events that led to the charge. It's no different here. Judge Smith didn't shift the burden of proof. All he said was, Gene has put forth a bunch of proof to show his intent. What do you got, state? If we look at the proverbial scales of justice that we have, the evidence was on the scale. It tipped it. All it said was there's nothing on this side of the scale to tip it back. That's all Judge Smith said.
Counsel, let me move you over to the venue issue because you're running out of time.
That's where I was going. Thank you.
I have the same question for the state, honestly. The decision to remand this dispute back to district court, it seems to me, needs to hinge on the burden shifting issue. I mean, if we found that the district court did not improperly shift the burden, then what effect does an error on venue have in terms of remand?
It has no effect. It's harmless error, Your Honor. And the case law recognizes that if it is harmless error, then the Bicknells have the burden of moving forth and demonstrating that it's harmless error. And as we put in our briefs, we've noted that the matter was heard by 2 appointed judges by this court. There was no there's no argument or evidence to show that the state was not able to provide any proof, subpoena witnesses, any effect on the procedure of the case. There's nothing to show that there was anything that would have been different other than the location of the courthouse. The state's brief says that it's prejudiced by the fact that cases can only be found harmless error in venue if they are submitted on stipulated facts. That's not the law. The Jones case that was cited by Judge Arnoldberger in her dissent and also in our brief was a case that was found to be harmless error on venue, even though it was submitted to a jury on contested facts. Stipulated facts can be a reason why there's harmless error, but it's not the only reason why there is harmless error. And there's been no discussion, nothing at all to show why this case would have been any different other than the location of the courtroom. And the location of the courtroom has no effect on the outcome of this case. So there was no prejudice to the state. It was, if venue was improper, it was harmless error, Your Honor.
Can you clear up just a factual phenomena here? In 2000, the KDOR filed a requested documents for 2004, 2005, 2006, but dropped the 2004. Was Mr. Bicknell considered a non-resident for tax purposes in 2004?
It was not, Your Honor, and that's part of our, one of our constitutional issues is that he was presumed to be a Kansas resident for 2005 and 2006 based on his filings prior to 2003. The regulations are clear that the State Department of Revenue can only act in accordance with the statute. And so if they wanted to change his domicile filings for 2003 and 2004, it had to go through the same procedures of challenging them, giving him notice, giving him a chance to respond, not just disregard them.
What happened in 2004? Was he considered a non-resident or a resident for tax purposes?
They audited it. He filed as a non-resident.
Correct.
They audited it and then dropped it. They did not change his residency. So as his tax returns sit for 2004, he is a non-resident of the state of Kansas.
And the fact that he was considered a non-resident in 2004, does that factor into any of the weighing that goes on in determining the 2005, 2006?
Well, he should have been.
You have to change, don't circumstances have to change from when you're a non-resident to when you're a resident?
Yes, I mean, he should have been presumed to be a non-resident for 2005 and 2006 then, absent some proof that he had changed, moved back to Kansas. Well, the Kansas case law says that you are presumed to be a resident of your domicile until you change it. And Your Honor, it is a factor because Kansas law holds that there is no one factor that controls it. So it's not a silver bullet by any means, but it is certainly a piece that leads more towards Gene's Florida residency, yes.
Clarification, the reason that they didn't go after 2004 was because there was some time limitation, is that right?
You'd have to ask the state that, but the statute of limitations, and there's case law on this, I can't remember the case right off, but it says that statute of limitation applies only to assessments, not to challenge prior tax years. So there were statute of limitations for them to assess, but there were no statute of limitations that would apply to them challenging the residency status of it.
Questions?
Can I just ask you briefly, counsel, are you conceding venue error, or is there a construction of the statute that renders venue appropriate in Crawford County?
We are not conceding venue error, Your Honor, and as we put in our brief, the Court of Appeals held that the order was effective in every Kansas county, just as it was in Crawford County, and it affected the Bicknells equal in each county. Well, if it affects the Bicknells equal in each county in the state of Kansas, then by definition it affects the Bicknells in Crawford County, which meets the venue standard. No. What we argued before the Court of Appeals was that The state contends that Gene lives in Crawford County. That's the whole point of the residency determination. Also, that we believe that the state has waived it by not preserving the necessary record for a trial transcript, both on the initial motion to dismiss, but also on a February 12th, 2018 journal entry, where they didn't even raise that issue as a point of appeal before the Kansas Court of Appeals.
But I guess what was persuasive to me on the venue issue is that by the time you guys are the issue is the effectiveness of the assessment for tax purposes, and everybody agrees Mr. Bicknell was a Florida resident by then. So it seems to me that there has to be, the effectiveness is either Florida, which of course could not be a proper venue under any notion, or really you're kind of stuck in Shawnee County. That's kind of the way I was looking at this. What's wrong with that?
Yeah, well, first, in their answer to our complaint, the state did not admit that he was a Florida resident. They filed that as a denial in their answer to our complaint. So this new concession that Mr. Bicknell was a Florida resident has only come up during the appellant process. So when we filed our petition before the Crawford County judge, or in Crawford County, I should say, the state filed an answer where it denied that Mr. Bicknell was a Florida resident. So therefore,
The argument is, if that's the position they're taking at the time that suit's filed, he could only be a Crawford County resident. I mean, he's not a citizen, he's not a roaming citizen of Kansas. So if he's a Kansas resident at the time of the filing, then Crawford County is the only place that works.
Yes, Your Honor. If you're going to claim that if the state is going to claim that he is a resident of Crawford County, then it shouldn't be surprised when he files the petition in Crawford County where they claim he resides.
Thank you, counsel.
Thank you, Your Honor.
Good morning. May it please the court, I'm James Oliver, and it's my privilege to present the case for the State of Kansas Department of Revenue. The majority opinion of the Court of Appeals is absolutely correct on the issues decided, but it stops short of deciding issues that are of critical importance that we have raised by cross-petition. And in the course of briefing, the supplemental briefing to this court, the Bicknells have had to concede material issues that undermine their arguments entirely. The position in which this case is before the court now allows it to focus on and decide the legal issues necessary to determine Gene's domicile, which are actually limited in number. I believe we can demonstrate to you that any disputes of fact are not material to the genuine issues, and that the evidence relied upon by the district court is not substantial evidence. And the whole argument that they made just this morning is that intent alone is enough to determine Gene's domicile, and the cases clearly say intent alone is never enough. Your intent must be corroborated by what the person does. Now, our presentation on substantive issues will also confirm that the Court of Appeals' decision to reverse on venue is correct. Every litigant is entitled to a trial of disputed issues of fact by a judge or jury in the venue provided by statute. And to answer to your question, Justice Biles, if it's a disputed question of fact, I think the authorities are unanimous, including the Jones case, that you're entitled to a judge in the correct venue, a judge or a jury, a fact finder in that venue, and that the venue statute is mandatory when you could reach a different result on the facts.
But Judge Smith was a senior judge appointed by us as opposed to being a local judge, and you could just as easily have been in Shawnee County with Judge Smith there as opposed to Crawford County.
No, the judges in Shawnee County wouldn't have had to recuse, and we would have had a sitting, active Shawnee County judge. And when Judge Smith is appointed, he is appointed to be a Crawford County judge in lieu of the recused judges. He's not a roving statewide judge. He's filling the role of a Crawford County judge. We would have otherwise definitely had a different judge.
So even if we were to disagree with you on the burden shifting issue, which to me is the only thing that makes sense about remand, that's why I'm probing here, because I'm trying to get you to convince me otherwise. So if you lose on the burden shifting issue, the venue thing seems like you're just shopping for a new judge to look at the same facts and maybe give you a different view.
I am seeking the right that I'm granted by statute to have a trial in a venue that's lawful, and that's Shawnee County, not Crawford County. And there's more reasons than just burden shifting to reverse and remand that I want to get to.
Is the county of a taxpayer's residence an appropriate venue?
There have been Court of Appeals cases on that that have been cited in our venue that say it can be if they're seeking a benefit from the state that's unique to them in their residence. But there must be a significant connection to the county by that taxpayer to have venue in an administrative case other than in Shawnee County.
So add to that, that they not only reside, but their primary business, all their business interests or primary business interests are located in that county, similar to the crop duster case, for example. Is that enough?
Well, the crop duster case involved a permit to engage in the crop dusting business. The businesses we're talking about here, and the other thing that I think was missed previously is the timing. The date venue is determined is not when this case started out, when the contention was you reside in Florida, or don't reside in Florida, you reside in Kansas. When the appeal was filed, that's when the petition for review in Shawnee, or in Crawford County, is the date we're looking at, and that's 2017. And at that time, Gene alleged he was living in Florida, and we took that as true and filed our motion, and that was that's the facts. We said, take it as true.
If you went on if you went on the merits of your case, is venue appropriate in Crawford County for the retrial? I mean, and we do have to have.
Can't be. It's their right to file a petition for review, which they did in 2017, and that's the date that venue had to lie in Crawford County based on their residence. They alleged it was Florida. We conceded. All right, and now.
Counsel, I'm sorry, before you move on from the point, so Crawford County is an appropriate venue if the order is effective in that county. So if I say you're giving an effective presentation, that means it's serving its intended purpose. But there's also a construction where effective could mean simply that it's in place or valid. I mean, why wouldn't that be an appropriate way to interpret the venue statute here, 77609, that anywhere the order is in place and valid, it is effective? Or how do you construe that term in 77609?
Well, it wouldn't be in there if the legislature intended to say venue is everywhere in Kansas because administrative orders are effective everywhere in Kansas.
Not all administrative orders are. I mean, there are orders that target particular counties, or orders of county officials, in fact, that can make its way through administrative review.
But, I mean, the statute says any order has to be effective, and the law has been construed to mean effective on a particular person, that is the litigant, in a place in Kansas, and that's the right construction, or otherwise, I think you have opened up state agencies to suits all over the place and a whole lot of forum shopping.
Well, then it means that there's potentially more than one venue where a trial could take place. And then you make your argument as to what is the most convenient forum and take into account the plaintiff's right to select that forum, right?
If that's what the statute said, yeah.
Okay.
A venue anywhere.
You just think, though, that
It's been written and construed to mean it has to have a particular place on the particular party in a location. And if his location is Florida, there's no county in Kansas other than Shawnee where venue lies.
well, we haven't construed the statute yet, right?
We have not.
Okay. And so your argument for your preferred construction over a more general, or the construction I've suggested as an alternative is what? Why is your construction better under our rules of statutory construction?
Because I do think you're reading out the meaning and intent of what is in the statute and would effectively nullify part of the statute with the construction.
And that is,
I really don't, it would be rare to me where, this isn't one of those cases where there's a particular statute affecting a particular place. This is the other option, which is anywhere.
right,
Where you got a non-resident, there is no such place and no possibility that a statute could operate effectively or in one county. There's no such claim in this case.
and your argument is it fails to give meaning to the alternative of venue is appropriate where the order is entered?
Well, where the order is entered is in
Shawnee County.
Shawnee County, obviously, yeah.
But is that the part of the statute you say loses its meaning?
No, effective contemplates that it's going to have a particular effect on a litigant in a place.
Okay, my question is
It can't
why
work if
is
it's a
that?
non-resident.
Right, and why is that the construction?
Because I think it's logical in what the statute says and is the intent of the legislature. The legislature did not intend for state agencies to have to go defend cases all over or continually fight with litigants over venue questions and convenience.
Because they could select a forum where there's absolutely no contact.
Yeah, or where it's inconvenient, yeah. And every time you just got to argue it again instead of being able to look at the statute and saying, here's the venue. Okay.
Before we leave, just a quick question, and it's because the record's so big, but can you refresh my recollection? Did you raise, or did the department raise an objection at the time of the trial to venue?
We preserved it all along. We'd already raised it and argued it and lost, and I don't know that we had to try venue as part of the case when it
Right,
had
no.
already been ruled on. I
Okay,
don't-
so, right, no, I just don't remember the facts. So
Yeah.
prior to the trial, you guys raised the
When they
issue,
filed it, we filed a motion
Okay,
to
got it.
dismiss for lack of venue
just to,
and preserved that
there's a lot of facts, I just don't
throughout.
remember.
Yes. All right, let me move on to the issue of Rita's domicile and what the effect of their supplemental briefs and their argument today conceding that they don't dispute that Rita's domicile was in Kansas. Well, that is contrary to the dissenting opinion of the Court of Appeals, which said as a matter of law it was Florida, and it's contrary to the opinion of the district court, which said that her domicile was a material issue of fact that Cador had failed to prove, and therefore he could impute Florida domicile to Rita. But the presumption that spouses have the same domicile is not a matter of imputation. It's a presumption supplied by law that may be rebutted as a matter of fact. That's all he said that regulation says. You can rebut it if you have evidence to do that. But Gene never disputed it as a matter of fact or law, and instead affirmatively admitted it. No evidence was required of Cador to prove it, and Rita was not the one contending she had changed her domicile. The burden is different and high on a person who is contending that they have changed their domicile. That was upon Jean. And but this, to establish domicile, is a stipulation of fact and law. And there was, I mean, Rita, they didn't make it an issue, didn't do any discovery on it. We asked, there was evidence already in the record about her Kansas domicile. She was a Kansas lawyer. She said she practiced law and did mediations, that she was involved with her grandchildren and Jean's children. She had parents and sisters that she wanted to visit here, and that she was actively engaged in managing political campaigns in Kansas. And
But all
that was just not an issue.
But all that I mean, as I understand it, all that means is that Gene gets tagged with Kansas because his spouse is domiciled, but he can overcome the tag by other evidence that he's domiciled somewhere else, right?
Yes.
Okay, and I think.
And I'm saying he had to do that by conduct, that intent alone was not enough. And he said, I never intended, to have a separate residence or have a different home than Rita, and wherever we went, we considered ourselves to be living together, which is a kind of nonsense and mendacity the law ought not to accommodate. And the evidence relied upon to establish a separate domicile has to be conduct, not just saying so, not just, I think harder that my residence is in Florida than Rita thinks hers is in Kansas. And what's the conduct that he has to establish? That he retired and moved to Florida. And that's the second material concession Gene makes in the supplemental briefs. He didn't retire in Florida in 2003. They deny he ever made that claim. They say instead that this is a red herring, but it's not. Gene, from the first audit inquiry through discovery and trial, said it was the issue that determined whether he had changed his domicile. He'd bought his house in Florida in 1990 with the intent of retiring there someday. And he knew that spending the winter months in Florida or being a temporary resident does not affect a change of domicile. So Gene wanted the district court to believe that his someday, when he had retired and moved to Florida permanently, had worked out, had finally come to pass in 2003. Let me stop here briefly to talk about the prior tax returns. You can't audit every taxpayer all the time or find what they're doing, and there is no rule that the state is stopped on the ground that I got away with it once, or I got away with it twice, and now you can't challenge it. There is no estoppel of the government to determine whether and when Gene changed his domicile, and there was an issue with time running out on 2004 under the 3-year statute, so why not pick the big years and focus on it? Yeah, he signed it under penalty of perjury, but if you want to talk about the extent to which that is evidence, you need to look at the Peck case. And Gene's, all the purport, that's why I say there's no genuine issues of fact here, because Gene's disputes were basically two of them. One, whether he spent less time in Kansas than his attorneys and he had previously reported and agreed was true, verified during discovery, that this is where Gene was spending his time in 2004 through 2006. In 2003, he had no evidence where he was, none. He kept no records except Post-it notes and writing on pieces of paper. He didn't tell his staff where he was, and he could not prove where he was present, except that it was undisputed that he did continue to work in Kansas, and he's now admitted in connection with what I'm talking about here, whether he retired, that he told the district court he reflected on retirement and decided on January 1, 2003, that he'd sold or given away some of his businesses. He didn't need to work anymore. He'd turned everything over to his son Marty, and he was ready to retire. And he testified, and he said, he was already taking care of almost everything, so I thought I would retire at January 1, 2003. He testified emotionally about the effect of Rita's breast cancer diagnosis. But now Gene acknowledges that he was just mistaken about the date that he accomplished these things. It was actually not until July of 2006, after he had sold NPC and received all the income that is the subject matter of this case. And if you look on your Kansas tax return, it asks you, are you resident, non-resident, or part-year resident, from, to. And Gene always rounded the whole years.
Mr. Oliver,
Yes.
before you're done, I want to get to the whole premise of the Court of Appeals majority is that there was burden shifting.
Yes.
And if we don't find that there's burden shifting, that the district court may have just been commenting and weighing the evidence and then making its findings, what do we do with that if there's not burden shifting? Are you asking us to reweigh the evidence or look at the evidence and find there's nothing there to establish residency? What do we do with that if we don't agree that there's burden shifting?
Okay, I am asking that, there was burden shifting, and he said so repeatedly, including on this very issue of the presumption of the spouse's residence. He said that we had to prove, in effect with a witness, that Gene was not telling the truth, and he disregarded undisputed facts. And this isn't just a fact case where you can defer to the district court for multiple reasons. Number one, fact-finding must be informed by the substantive law, correctly identifying what is required to be proved and what evidence is required to prove it. And it was conduct, moving to Florida, not going to Missouri. You can't move away from Kansas by going to a new temporary residence in Missouri for months out of the year. You had to go to Florida and make your home there. You have to both abandon Kansas and acquire a new residence in Florida. And so you got that issue. Did he apply the right law? And two, fact-finding must be stated separately from conclusions of law, not commingled and conclusory. You have to be able to determine whether the court correctly applied the law to the facts. That was the point of the previous remand, and this decision, you're less able to do that than with the previous Court of Tax Appeals decision. A fact-finding is not made correctly if the burden of proof is defective and cannot be relied upon, if the court doesn't demonstrate that he actually did it. And findings cannot ignore the undisputed facts or conflicting facts when they can't both be true. And there are numerous examples where the court's findings, they're just colossally wrong and documentably so, and I wish I had more time to explain all of those to you. The worst one is when the court, one of the worst ones is when the court said Gene had been living in Kansas only for a short period of time before 2003. He based that on finding that Gene changed his residence to Florida just by going there in 1999, at the same time registering to vote and getting a driver's license, and then going back to Kansas. There was no corroborative evidence that he actually moved to Florida at that time. Gene said it wasn't true, and elsewhere in his testimony, Gene said it didn't work out until 2003 that he could move to Florida. And Gene filed resident tax returns for 2000, 2001, 2002, but the court said the prior residency weighed heavily in favor of Florida and cited a case to say that lowered Gene's burden, an Arizona case, when in fact he had never by any means lived in Florida. And this court held in Peck that you cannot make a residency on paper. You can't just driver's licenses. That may have some relevance, but it's transient. You can change it easily, and it is not evidence of a permanent intent to establish a new home, just that you did paperwork. For example, the 4 trusts Gene signed, during this 4-year period. They recited he was a resident of Florida, but every one of them was signed in Kansas. Witnesses, yeah, is that evidence you live in Florida, or is that evidence you don't? There was this huge conflict over stuff that was just nothing. Whether he was in Kansas 30 days or 112 days a year, he still never abandoned Kansas. And if he was in Missouri, in a temporary residence there, he was saying every time he emphasized that, I don't want to be in Florida. I don't intend to live there. I'm not staying there now. I have no present intent to be in Florida.
Can't the same be true of Rita, though?
No. Why do you say that? I'm sorry.
Because, it seems to me that, she intends to be a Kansan. But she spent a lot of time in Florida during the years that are relevant there. You're trying to argue that they didn't live apart, but they were outside of Kansas when they were together. It seems to me just as likely that a Kansas resident can spend a whole bunch of time over several years in another state, but still, have Kansas in their heart and intend to be a Kansan. That just doesn't.
Okay, well,
It just seems it seems to go to the ability of Gene to rebut the legal presumption that he gets tagged with because Rita's a Kansan. That's all I'm getting at here is, how do you prove that presumption? And you were trying to say he has to show that they lived apart. But why can't a Kansan live in Florida for long periods of time with him?
okay, but my problem
there's a
is
disconnect here.
the Rita's domicile was not an issue, not a disputed fact, nothing we had to prove. But the fact is, you can look at the country club records and things like that, and you'll see Gene said he was gone by March. Somebody was there in Florida making charges until the end of May, and then gone until the end of December, 7 months. I think the evidence was Rita was in Florida more than Gene. That doesn't mean, and she had no burden of proof, she could retain a Kansas residence and did, on purpose. She considered it her home. Gene was, and that's what domicile means. You establish a home with the legal consequence that becomes your domicile. What Gene did in Florida was take a nice winter vacation, and he said that. When I'm in Florida, I'm watching the sunsets and playing golf, but the business of life goes on in Kansas. And Rita said, Gene, she didn't change her domicile to Florida because she wasn't done with the thing she was doing in Kansas until 2008, and that's when Gene's shows ended, and that's when he had time to go to Florida. So the whole premise that Gene was ever living in Florida, except 3-4 months out of the year, the winter months, and Rita happened to be there at the same time, and Gene actually argued this before. Well, you can't, in the Board of Tax Appeals, you can't blame me for having a house and a home and cars and going to Kansas because that's where my wife lived. I was just visiting her. And when I'm in Florida, she's visiting me. Well, I am saying the law does not allow just different state of mind to change a person's domicile. Gene could not move Rita to Florida involuntarily, and neither could Judge Arnoldberger by saying it's a question of law. It's not. It's a question of law and fact, and they stipulated to it, and we didn't have the chance to try it. And that's burden shifting. If you're arguing about an issue we never had a chance to try or prepare for or get evidence disclosed to us on. That's just wrong. And so the whole thing here is you can't accept intent alone as enough. And they haven't said what evidence other than state of mind and writing it on paper. Gene lives in Florida, either whether it's 1 time or 10 times or 20 times, doesn't make it so. It has to be corroborated by going there with the intent to establish a permanent residence and stay. And he always went with the intent, like 2003, Rita had cancer. And that's what really convinced the district court to shift the burden of proof. He said that leaves no necessary doubt about Jean's domiciliary intent. Well, intent isn't the only issue. There is necessary doubt because it has to be corroborated by conduct. And when Rita was better, they went back to Kansas. By May 24th, there was no more charges on their Florida Country Club account for any meals. They'd started having charges on the Kansas Country Club account. Rita wrote back to Florida Homeowners Association saying, "We look forward to seeing everyone in the winter," in June of 2003. Jean bought a new car at the Pittsburgh Ford dealership in July, which said it was sold to Gene Bicknell of Pittsburgh, Kansas, and he applied for a title for it at the Pittsburgh DMV in August 12th of 2003. On December 31 of 2003, Gene signed one of these trusts saying he was of Englewood, Florida. But it was signed, notarized, and witnessed in Kansas. He was there on December 31, 2003, and his lawyer asked him then, "Well, what about Rita's health now?" And he said, "She's okay, and it's okay for me to go on and go back to, go over here to Missouri and start rehearsing this show and putting it on for the next 3 years."
Mr. Oliver,
Yes.
in concluding, what do you want us to do? Is this just going to go back, venue, Shawnee County, start all over again? Is that what we're doing? If we,
I mean, I really genuinely believe that you have the issues before you that can dispose of this case as a matter of law against Bicknell's. They've admitted he did not go to Florida, he did not retire in Florida, that he has no evidence other than his own intent of a separate domicile than Rita. He cannot rely just on driver's licenses, executing trusts, things that take only a minute to fill out or easily changed. They're not evidence of permanent domiciliary intent under the Peck decision, and you should follow the Peck decision. But if we have to go back, the law should be clear, the law should be applied, and that's what we're entitled to. The same laws that apply to every other Kansas resident should be applied to Gene with no exceptions to what he was oblivious to or what he thought the law was. There is no way to move to a new domicile except to go there and live there and make it a permanent home. And he's trying to do it by other means, like I'll go to another state and I'll stay there. Or I'll get a driver's license. And he had driver's licenses in both states. That is not evidence. There's no genuine dispute, but we ought to get it. If we have to go to trial, we get it with the right burden of proof, not this deference to Gene. And, okay, thank you. We do want a new trial. All right, thank you.
Reserve 4 minutes.
May it please the court, thank you, your honors. What we just heard was the exact closing argument we heard before the district court. That's why this court does not weigh facts. That's why Judge Smith had the ability to hear the evidence, had the ability to weigh witnesses, had the ability to hear Mr. Oliver's arguments on all those same points. And it's why the district court still found that Mr. Bicknell had demonstrated his necessary intent and removal to create a Florida domicile by, quote, clear and convincing evidence. I will not go into the recitation of facts as Mr. Oliver did for the reason that this court does not weigh facts on that. However, there are a couple issues that I do want to address. Justice Biles, to your question about can a person live in Florida and maintain a domicile or spend a lot of time in other places, yes, they can. And as it relates to it, that's why intent and the objective factors that go forward relate to that. Gene was asked, why didn't he sell all of his businesses? Why didn't he fire his personal assistant? Why didn't he move away from his family? Why didn't he, or why was his family still located in Pittsburgh? Why? All these questions that forced him to just have a clean break from the state of Kansas. And Gene's response was, I didn't want to divorce Kansas, I just didn't want to live there anymore. And the burden the state wishes to impose. This is from their appellate brief to the Court of Appeals. And Justice Wilson, it goes to your question about other facts that may have applied to hold venue in Crawford County. According to the state, in order to change domicile, if Gene wants to move to Florida, it, quote, means we relinquish our opportunities to work, achieve, earn, and receive the honor afforded to high positions and accomplishments in business and community. If we relocate to a sunny place like Florida, we may gain nicer weather seasonally, but we also leave behind the neighbors and the family year-round. That's italicized. We miss the grandkids and great-grandkids' social and school and church programs, sports, more frequent family gatherings, and overnights at Grandpa and Grandma's. The state's burden seeks to impose upon Gene that he can't see his grandkids. He has to have a complete break from the state of Kansas. He has to get rid of his businesses. He has to fire his assistant. He can't see his family anymore. That's not the law. And so when you're Gene Bicknell in 2017 and you're looking, is this order effective in Kansas? Is it effective in Crawford County? Yes, it absolutely is, because otherwise, if I don't stop seeing my grandkids, if I don't stop seeing my friends, if I go back to Crawford County at any time, the state of Kansas will seek to impose further tax liability on me. That's the standard that they're seeking to impose here. That's not the law. There's not a single case that the state has cited that says if a husband and wife live together, that automatically equates to domicile, that they have to share a domicile and that cannot be overcame at all. Not a single case says that. In fact, the regulation says the exact opposite. So when we're looking at this, we have to look at the facts in context as to what Gene's intent was, what he did. His burden is not to show that he has an that he can never come back. He doesn't have to divorce Kansas. He just has to show that he didn't want to live there anymore. We ask that you overrule the Court of Appeals decision. We ask that you reinstate the district court's decision and put an end to this 14-year saga. Thank you.
Counsel, one of the things that I didn't bring up before, but I forgot, but besides the presumption, the spousal presumption problem, the other thing that bugged me a lot was the fact that Mr. Bicknell was a resident agent for a whole bunch of corporations, and it seems like you can't be a resident of Florida if you're a resident agent for a whole bunch of Kansas companies. And I understand the facts about, sort of the business flowing along like a juggernaut, and so, but honestly, isn't that, in the grand scheme of putting some facts over on one side of the ledger and other facts on the other side of the ledger, isn't that just a bad fact for you?
Sure. I mean, there are several things that, honestly, when I took this case, there are several things that I looked at and I said, if this was an intentional plan to deceive the state to try and get rid of taxes, it had been done a heck of a lot better than it was. There are some facts here. This shows that this was true life. The messiness of it shows that it was true life and that Gene wasn't intending to deceive anyone. The court considered all of that, the district court. They spent a day with Mr. Bicknell, an entire day going through each of these registered agent forms and saying, is this your name? And Mr. Bicknell looked at them, each one of them, and said, I didn't sign that, Karen did, or Cindy did. And the court looked at that and said, what does that mean to Gene's intent? Did Gene do this with the intent to declare that he was a Kansas resident? Or was this just someone carrying on with the business and filling out a form? And the court said that that was not an expression of Gene's intent sufficient to carry the day to outweigh all of the other facts that supported a Florida domicile.
Any other questions?
Thank you for your time today, Your Honors.
Thank you to both counsel for your arguments. The court will take this appeal under advisement.